the managing partner or the partner in charge of the property, the mortgage area, and explained to them that their clerk can't be insisting on a solicitor's certificate remotely.
Yeah.
So yeah, we will try and do that, particularly with the banks.
Yeah. Okay.
I'm interested to hear what people thought when they read the article. What was your reaction to it? And could you put your, is there something in that that's an issue you've had to deal with in your practice?
I can just say, as a junior lawyer, you always had the partner signing the stack of stacked decks, and then drags you in after they're signed, and the junior, I always said, just sign them again. And that doesn't do anything for your promotional chances.
No. But we've all had that.
And I don't want to name the people, but it's, there's one in particular who did it all the time, no matter how you approached it. And it I guess that's why articles like yours, you can say the same thing in 10 different ways. They're actually very useful for the junior simply to point it, just pop that on his chair.
Yeah. Yeah. And to give them the the strength to know that they're right and the partner is wrong. Yeah. Yeah, that was part of the reason for writing it too, to bolster the junior lawyers' positions.
All right. Is there anything else that we need to do? I guess you said you're thinking of how to expand this further. Is there any, Heather, anything that any particular thing that you'd want from the notariate that we can work on, or individuals come back to you on?
Yeah, I'll come back to you on that. Where it's sort of at the preliminary stages. We've written an issues paper that we want to bring the LIV, LSB, and barristers Vic Bar in together to talk about what we can do collaboratively. But do you think there's a place for having a sort of a more specialised hotline that practitioners can ring when they've got that too hard basket file for advice?
I think that Derry Devine and GST is working incredibly well.
Yeah.
And he says, no nonsense, cut it back to the question.
Yeah.
I don't need the paperwork, and his turnaround is very good. And I think that's a service that you know the answer, you just want to tell the other side. So it's well, sometimes you don't know the answer as well, but
yeah.
I think that sort of a that help, but just reinforcing good behaviour is very helpful, I think.
Yeah. I also wonder whether we need some kind of campaign, promotional campaign, to encourage people to ask. It's great. It was great to hear tonight that you were saying you were happy to ask someone. But I think, do you think there are practitioners out there who feel that they can't ask?
I think so.
Alan Wong, did you mean to put your hand up? No, it's okay. It's just showing up on the screen. Don't you love Zoom?
All right. Okay. Well, let's move on from here, perhaps, Heather. And I know you're welcome to stay for the rest of the meeting, but I think you've got a board meeting or something, and we're always harrowing. So
yes, I would love to have stayed to hear your talk, Peter. But maybe next time.
No, thank you for your time, Heather, and thank you. Appreciate it. If there is anything, then just drop Peter a note.
Yeah, and feel free to follow up if you've got any thoughts afterwards.
Okay.
Or you hear of anything that you think's working really well that we should know about.
Okay.
Okay, terrific. Thank you.
Thanks very much, Heather. All right. If we could now move the agenda a little bit backwards, and perhaps if I could ask Michael Buller, can we turn to page 2 of the agenda at 3.1? And Michael, the floor's all yours.
Thank you very much. Just an update on SMV events. As you can see, it's an action-packed year. We've already had our Twilight Seminar, and our next function, which will occur, is the Consular Cocktail. I urge you all to join with us. There are limited numbers. It's an excellent opportunity to meet the consuls, and after all, we are document exporters to the countries the consuls represent. So that will be on the 22nd of June, Wednesday, at BDO in Docklands. Just go on the website, log in the shop you can find the booking form, so do that. We have, of course, next after that, apart from webinars continuing throughout the year, we have, of course, the wonderful annual dinner, and Philip Earle is with us today. We are very honoured to have the IBAC Commissioner as our guest speaker, the Honourable Robert Redlich, AMQC. Should be an action-packed speech, I'm sure. And we're at the Trilogy Room at the Hyatt on the Park, wonderful venue, where we were in 2019 when we received Peter Kidd, the Chief Judge of the County Court. So we've had a pretty good run of guest speakers, so I urge you to all support us for that. Then the study tour is taking place. We've had more numbers than we expected. A fantastic opportunity to understand the civil law, how our documents, our notarial acts are received in Europe. And we're going to 4 of the leading civil law jurisdictions from the European point of view: Italy, Switzerland, Latvia, and of course, France, which I can assure you took a bit of organising. So that really is a great success. And then apart from that, we have our AGM, which is on the 24th of November. I urge new and not so new notaries to run for council. Council is the blood and the administration and the management of this society, and I urge you to present. There you have it. That's the year as we've got it planned. I think it's a great year from the point of view of CPD, of learning, networking, and certainly education, apart from the cultural aspects of travel to Europe. Thank you.
Thank you, Michael. It just occurred to me that we're in the Trilogy Room and we haven't had an annual dinner for 3 years. So that's very good. Can I now ask Peter to talk to us on something new, and I'll just hand over to Peter, please. So we're at item 5, please.
Well, thanks very much, David. Formal good afternoon, colleagues. It really is a new world out there. I don't know how much we really appreciate that, but this topic today is part of that new world for the public and for us as notaries. And I'll be talking about notarially certifying e-signatures and e-signed documents. Now, I've prepared a practice note with some precedents, which will be distributed tomorrow. What I was thinking of this afternoon, I'd actually done precedents largely based on corporate documents. And I thought overnight I'd do a new precedent that's for private individuals as well. So forgive me for not having it immediately after this, this webinar is over. Now, the practice note covers all the matters that I want to be discussing this afternoon. So let's get on with it. Now, the Electronic Transactions Act 1999 at least, was the federal legislation, and that was passed in, God, 23 years ago. It's followed by corresponding state and territory legislation, including in Victoria, the Electronic Transactions Victoria Act 2000. Subject to various legislated exemptions in Victoria, as in the rest of Australia, electronic signatures have been the functional equivalents of handwritten signatures for many, many commercial purposes. Now, just for what this is worth, electronic signatures have not replaced handwritten signatures for all of these purposes. It's just an option, but it's an option that's been taken up and used in government and legal and commercial circles. And it's an option that has gathered pace since the onset of the pandemic and the normalisation of working from home. But notably, the public at large has not yet embraced the technology. And as a rule, people generally still rely on handwritten signatures for important documents. I think most people would be extremely surprised to know that when they're typing their names at the end of an email or clicking an add to cart or buy now button when they're shopping online, that they're in fact using forms of simple electronic signatures. Now, essentially, there's actually 3 levels of electronic signature that are recognised and used differentially throughout the developed world. The first level is simple electronic signature. The second is advanced electronic signature and qualified electronic signatures. The term simple electronic signature presently covers several different forms. I think most of us are familiar with them. Firstly, as I said before, a click button such as buy now or add to cart when you're shopping online. Secondly, a scrawled name or a mark made by a stylus or another implement or your finger on a tablet or a similar device. Thirdly, a typed name at the foot of your email. Fourthly, an avatar placed in the signature panel of an email. Next, a facsimile of a handwritten signature pasted onto an electronic document. And finally, a commercially obtained software generated signature such as, well, we'll get onto those, but such as DocuSign. Now, they're simple electronic signatures. The advanced and qualified electronic signatures are secure electronic signatures based on asymmetric cryptographic public key infrastructure technology, and they're colloquially called digital signatures. The term digital signature is reasonably well known in legal and government and commercial circles, but very few people, I think, in those circles actually understand or are familiar with the technology. And other than for transactions that require a level of secure, verifiable electronic communications, digital signatures are not commonly used within the public and private sectors on a day-to-day basis. So accordingly, my remarks in this webinar are not directed towards digital signatures. My focus is on e-signatures, that's simple electronic signatures, and in particular upon commonly used e-signatures generated by software and sold by commercial providers such as Adobe and DocuSign and EverSign and HelloSign and SignRequest. DocuSign is thought to be the current market leader. They say that they have over 200 million customers worldwide. We certainly use a lot of DocuSign signatures here in Australia. And as I'll hope to show you shortly, notarizing e-signatures and certifying their legitimate use is no more difficult when notarial intervention is required for a top-tier public or private sector organisation, or when the same service is provided for an organisation at the other end of the spectrum, or for an individual signatory. Now, anecdotally, the e-signatures of officers and executive and managerial staff within a good many of Australia's public and private sector organisations are regularly affixed to documents by secretarial and administrative personnel. And apparently it happens a lot without the specific consent of the nominated signatory. Typically, it happens in circumstances where it's thought that the nominal signatory would really have signed this document electronically had he or she been asked to do so. And you'll all remember the debacle over the Victorian government's service contracts for the quarantine hotels at the beginning of the pandemic. And you'll all remember the Sergeant Schultz defence that was taken by so many people at the time when asked, well, who signed the contracts? Who was responsible? And the answer, of course, was, we don't know. I wouldn't have a clue. Well, indeed, it turned out that the documents, the contracts, were signed electronically by Simon Femister, the Secretary of the Jobs Department. But he signed electronically, or did he? He has subsequently said, oh yes, he approved the signing of it. Well, who am I to disagree with a senior public servant? But I do know that his signature was affixed to the contracts by a very senior staffer, and that fellow signed as witness. Now, only in the Victorian Public Service could that happen. But despite the number of occasions on which e-signatures are thought to be affixed to documents by persons other than the nominal signatories, there's remarkably few reported cases on the subject. The leading case is a thing called Williams Group Australia Proprietary Limited and Crocker. It's a 2016 New South Wales Court of Appeal decision. And the Court of Appeal unanimously upheld the trial judge's decision to set aside a director's personal guarantee when the director or director's e-signature had been affixed to a credit application and guarantee without his knowledge or authority. And in its unanimous judgment, the court observed, at least obiter, and I quote, "There is some authority that would support the conclusion that the placement of a genuine electronic signature on a document without authority could amount to forgery at common law." If I can turn now to the matter of signing company documents electronically. When the original electronic transactions regulations came into operation in 2000, there were more than 1.7 million companies registered in Australia as at July 2000. Now, for reasons best known to themselves, pardon? For reasons best known to themselves, the politicians and public servants involved in making the original regulations decided it wasn't appropriate to allow Australian companies to provide information, documents or signatures electronically. Therefore, the original regulations exempted the then corporations legislation from the ambit of the Commonwealth Act. 20 years later, on the 29th of July 2020, at a time when there were more than 2.7 million companies registered in Australia, the 2020 regulations came into effect and replaced the original regulations. And when that happened, they provided an updated list of Commonwealth laws that were exempt from the provisions of the Commonwealth legislation. And that list included the Corporations Act. Among other things, thereby, it continued the rather curious previous decision to bar company officers from signing corporate documents electronically. But following several temporary measures hurriedly put in place during the pandemic by the former federal government, and to assist Australian corporations by allowing their officers and agents to sign documents electronically, with effect from the 23rd of February this year, by virtue of the Corporations Amendment Meetings and Documents Act, the Corporations Act now permanently allows a range of company documents, including contracts, minutes and deeds, to be signed electronically by company officers and authorised agents. And you need to look at, Section 9 of the Corporations Act, which defines documents. And it's a very, very wide definition. And so company officers and agents, including attorneys, or as the Yanks like it, attorneys in fact, to make a distinction between attorneys in law. But the corporations legislation allows company attorneys, company agents otherwise appointed or deemed to be agents, and company officers to sign a raft of documents electronically. Now, before we get on to how we authenticate it, the critical question is, are e-signatures acceptable abroad? It's all very nice, we've got legislation, but the critically important issue is whether if a document signed by an electronic signature is an acceptable document or an acceptable means of signing personal or commercial documents to be used in particular jurisdictions abroad. Now, I'll give you a few examples, not exhaustively in each case, but half a dozen examples. In Argentina, most government agencies do not accept e-signed documents, and only handwritten wet ink signatures may be used to sign family law and inheritance documents. The government entities in Brazil all have their own individual rules, and they're not obliged by Brazilian law to accept e-signed documents. Most documents may be signed electronically for use in China, provided that the electronic signature is considered reliable. That is, it's provided it's certified by an electronic certificate service provider approved by the PRC regulatory authorities. So the impact of that is that for documents going to China, and remember that 16 or 17% of all of our documents as we deal with as notaries are going to China. E-signatures are not acceptable for any purpose whatsoever in China or in the PRC. No matter what people tell you, I'm telling you that is right. Now, the other place where we get lots of documents going is the Dubai International Finance Centre. E-signatures are not acceptable in Dubai on documents creating or enforcing local or foreign powers of attorney, and that includes board minutes authorising the grant of a power of attorney. E-signatures are not acceptable for the signing of documents pursuant to a power of attorney, with the result that handwritten wet ink signatures must be used to sign all of these documents. In Indonesia, it all depends now on the policy of individual government departments and public sector institutions. But e-signatures are not allowed in Indonesia on notarial deeds or documents relating to real estate transactions, all of which require handwritten wet ink signatures. And finally, the almost inviolable rule throughout the world's national intellectual property offices is that all documents creating or affecting intellectual property rights must be signed with handwritten wet ink signatures in order to be registered. Now, that's not when patent attorneys are lodging documents, but when the intellectual property documents are being dealt with subsequently, handwritten wet ink is exactly the only way it's going to be dealt with. So even though on occasion an experienced notary is able to assist an existing or prospective client as to the acceptability of e-signatures for specific purposes in specific jurisdictions, ultimately it is for the client to obtain advice in advance of signing documents directly from the client's own correspondence abroad in relation to the acceptability of e-signatures. Right, I'll repeat that. It's the obligation of the client, not the notary. Don't put yourself in the position that you're going to outsmart everybody by telling them what they can and cannot sign electronically. The client's duty is, and it's your duty to tell the client, if they ask you to do it, it's the client's duty to find out from their people abroad whether the e-signature will be an acceptable signature on the documents to be signed. And ordinarily, discussions and decisions have to be between the client and the client's correspondence abroad, and not between you as a notary and the correspondence abroad. Now, it's for the client then to confirm to the notary whether or not, for the purpose of the particular document, these signatures are acceptable. And if so, whether particular forms of e-signatures are acceptable, such as DocuSign. Now, I know I've hammered this point, but it's terribly, terribly important. Just don't go out on a limb and do yourself a disservice by thinking that it's just possible or not possible to sign a document electronically or with a particular type of e-signature. So, as you know, witnessing and then certifying the signing of documents by identified signatories using their handwritten wetting signatures is a commonplace notarial service. Currently, and I'm not saying this isn't going to change in the future, but currently, e-signatures are almost never affixed to documents by identified signatories in the presence of notaries, either in person or online. Now, just think about that. It just doesn't happen as a matter of practice now. Accordingly, the circumstances in which a notary is able to personally certify the genuine nature of an e-signature, or who actually affixed it to a document, are few and far between. So there is a solution to that problem, but when the occasion now demands, and it is being demanded more and more, notaries have to resort to an alternative means to allow us to certify the veracity of an e-signature or an e-signed document or a copy or printout of the document. And we've got to go back to basics and adopt a means long since employed by notaries internationally in their interventions. And that means is the taking and recording of declarations. And taking and recording declarations by identified individuals as to facts, matters, and things continues to be good notarial practice in all civil law and common law jurisdictions. For example, in France, a notarial act of notoriety is a public instrument prepared and issued by a notary at the request of an interested party that records the declarations of usually at least two appearers who testify to the truth of facts concerning matters proving kinship for inheritance purposes and correcting errors in official documents. Notaries in all the world's littoral states, including Australia, traditionally have prepared and recorded notes of protests by ships' masters in relation to incidents at sea. A protest being the master's personal declaration as to events that have alleged to have occurred. And for those of you who have done ships' protests, you'll know that when an extended protest is prepared, Australian notarial practice, which is similar to the English practice, is to have the facts set out in the instrument verified by a statutory declaration made by the ship's master and senior officers. and that declaration is appended to or forms part of the instrument. Thirdly, a notarial act of honour made pursuant to Australia's Bills of Exchange Act, Section 73 of that Act, is founded upon a declaration made to a notary by or on behalf of a payer for honour as to his or her intention to pay the dishonoured bill of exchange. Now, that provision is in the same terms as the identical provision in the English Bills of Exchange Act, which codified the then existing common law in relation to the subject of bills of exchange, and similar provisions are found in the legislation of most former British dominions and colonies, including the Bills of Exchange Acts of Canada, India, Jamaica, New Zealand, Singapore, and South Africa, and others. Now, the reason I'm hammering this point is because it shows that previously and now we are entitled to take and record declarations by identified people made before us and rely on those declarations when we're asked to notarise documents. And in particular, when we're asked to notarise an e-signature or an e-signed document, we can properly do so on the basis of the declaration made by an identified individual. Now, when I'm talking about an identified individual, I think it's reasonable to say that that person is reasonably to be expected to make a truthful declaration concerning the facts to be certified. I'll come to this in a minute, but to assist recipients abroad, notarial certificates should also include brief statements as to the relevant aspects of Australia's electronic transactions legislation, and in applicable cases, relevant aspects of the Corporations Act that allow the use of e-signatures in the documents of being notarised. So for the purposes of a notarial act, either in public or private form, a notary's simple duty is to take a declaration orally or in writing and record its making in the act. Now, Victorian notaries do not have any investigative or quasi-judicial function and are not obliged to go behind a declaration or comment on its veracity. We shouldn't do so even if we're asked by a recipient abroad of the Notarial Act after it's been received, or if the proposed overseas recipient has sent a suggested certificate requiring special comments about the veracity of declarants by the notary. It's very well established in all civil law and common law jurisdictions that we as notaries have no responsibility if declarants are mistaken or less than truthful in their declarations. Okay, and even if you find it difficult to believe a declarant, it's not for you to go behind the declaration and investigate either the declarant's bona fides or the substance of the declaration. If courts or interested persons abroad want to pursue the veracity of declarations recorded in a notarial act, they are at liberty to contact and deal directly with the declarants and the signatories, and where applicable, they are at liberty to make arrangements to receive and view e-signature audit trails. And if a declarant or a signatory prevaricates or declines to assist, then an appropriate conclusion doubtless will be drawn as to the reasons why that occurred. Now, if I can, I'm conscious of the time, a couple of comments on the contents of the precedents that you'll be receiving. People abroad need to know essentially that it is lawful in Australia for somebody to affix an e-signature. And so you need to be saying in your notarial certificates, and as I say, I've set this out in the precedents, you need to make a statement that by virtue of Australia's national electronic transactions legislation, electronic signatures, or in this particular case, e-signatures, are the functional equivalents of handwritten signatures when affixed to commercial documents. And when you're dealing with corporations, you need to say that, among other things, Part 1.2AA of the Corporations Act authorises officers or agents, but officers of Australian companies to sign documents with their e-signatures. And then in the particular case of a company, you will say that X, who may be the company secretary or a director or whoever, has declared to me in proper form of law that the signatures of the e-signatories on the power of attorney or whichever other document purporting to be the e-signatures of A and B are their genuine e-signatures, and in the case of a corporation, the e-signatures were affixed in accordance with the company's e-signature protocols. It's not hard. It's just instead of saying, look, I saw Bloggs sign this document and this is his true signature and proper handwriting, you are taking a declaration either from Bloggs, who has declared to you, this is my true signature, my true e-signature, or you're taking a declaration from a company officer saying, this is the true e-signature of A and B, and it was affixed in accordance with the company's protocols. Now, it's not difficult, but you don't have to go to water when you see an e-signature, and you don't have to pursue the matter and investigate it. It's not your job to be an investigator. It's never been a job of a notary to investigate declarations made in a whole raft of areas. I hope that's clarified the subject a little bit, and I hope that you'll appreciate the subject a little bit more when you read the paper. Thank you very much indeed for your attention.
Thank you enormously, Peter. Very insightful and very helpful. We look forward to getting the paper. I've got a question in the chat, and I think you've answered the question, but the question is it not the responsibility of the client to determine the acceptability of the document in the jurisdiction that the document is to be used in? And I think you've answered that question.
Unquestionably so. But on the other hand, when you are saying, the fact is that notaries do not give transactional advice. But the truth is, in fact, if it's a good client and you think